So having won on count 3, why are you appealing the other 5?
Well, count 3 is a nice ruling as far as we're concerned. However, when it comes to the question of whether or not the Park District is authorized and or should be selling this land, we really don't have a ruling on the merits. What we have is a ruling that this wasn't a public sale as required by the statute, but it's been our position all along that this property shouldn't be sold at all, and there's no authority to sell it under the public trust doctrine as well as the public use doctrine, and that the statute that allows for this sale is unconstitutional. We'd like to have a ruling on the merits of those arguments.
Well, the judge did give you a ruling, right?
Well, he rather broadly said he didn't think they applied. As much as I like or think Judge Martin's a very smart man, he really gave no reasoning as to why he did not think they applied, and it's our position they do. There's no real good reason that I can see why they should blanketly not apply.
So you anticipate that the appellate court will, in making its ruling, give a more detailed explanation as to how they reached that?
At the very least, it's our hope, of course, that they'll overturn the judge's ruling.
The time frame on this, how long will this whole appeal process take?
Once the notice of appeal is filed, there's 63 days to file the record on appeal, which is all of the documents regarding the proceeding that happened at the trial level, together with transcripts of those proceedings. After that, the appellant has 35 days to file a brief. That's us. The appellee, who would be the Park District in this case, would have 35 days to file their brief, and then the appellant has another 14 days to file a reply brief. Typically, those time periods are extended, often at the request of the parties. They'll be extended. Also, when it comes to filing a record on appeal, even though the clerk is required by the statute or by the rule to file it within 63 days, that time often gets extended simply because of the logistics of pulling together the record. They often simply can't accomplish it that fast.
So when do you anticipate you'll actually be making an argument before the appellate court?
Well, after the briefs are filed, it's up to the court to review the briefs and then decide whether or not they want to have oral argument. And once they decide that, if they're going to have oral argument, they schedule that date. That is often substantially after the briefs are due, usually in the area of 6 months to 9 months after the appeal is filed. A ruling usually comes 3 to 4 months after that. It is fairly common for an appeal to take a year.
So you don't anticipate any kind of resolution on this matter until then?
That's correct.
In what way will this appeal process affect other legal actions that are ongoing? Other efforts by the Park District to sell the land?
It could have an effect on the other proceeding because defenses that could be raised in that proceeding are being raised in this appeal. So, arguably, if the court in the other proceeding, and I'm not sure how to describe that for your viewers, but in the other proceeding, which is a petition which argues that the land is less than 3 acres, and so the court can make a determination of whether or not the land should be sold. If the court in that case agrees that it's less than 3 acres and goes forward, the same defenses, that is the public trust doctrine, the public use doctrine, would be raised in that case. At that point, we may well ask the trial court to stay its proceeding while the appeal in this case is going forward.